This lesson is about the process how to change the law. In particular, why, how it happens, and also some elements of law reform. Let's start with why. Essentially, changing values and attitudes and the advances in technology provide two big reasons. Other reasons could include environmental reasons, where people want to protect the environment or have addressed to climate change, and in some instances economic systems change as well. Let's look at this particular point. The main point for the law to remain acceptable, and as change occurs, the values in societies change as well. So if that occurs, then the obvious thing is that the law must also change with it. One example here is that as a society becomes more accepting of same-sex couples, then the law should also reflect this. There's been a lot of news of that lately. The present government has resisted the change, one could argue, to have a plebiscite, which is a vote by all the people at the next election just on a particular issue, or it could be outside the electoral cycle. But there's lots of evidence to say that the values have changed and therefore the law should change with it. Previously, the Relationship Act in Tasmania in 2003 has already recognised people living in those arrangements, but the formal recognition in terms of a marriage has not yet been extended to those people. Another such example is changes in technology. As technology changes, a lot of new situations arise where people can be exploited or are harmed, either physically or economically. So the laws need to change with it. One example here is identity theft. This is not yet legislated in Tasmania, but in Victoria they've got the Crime Amendment Act, where there is a statute to outline what constitutes identity theft and what sanctions exist if that crime is committed. There's lots of pressures to change. The first one I wanted to look at are the informal pressures. They're the ones that we hear about in the media and on the internet. The most common ones we hear about are demonstrations and protests. People have public meetings and also informal meetings where issues can be raised and further discussed and issues explored within a society, within a country. The old-fashioned way is by doing it in the written form, letters to the editor, for example, or letters straight to the politician, your representative. That's still an effective way. But these days there seems to be a lot more online e-petitions that are, I guess, an easy way to canvass support and opinion. Now these informal pressures are used by media, by the TV media or the social media, and these days, because they're so prevalent in our lives, they're very vital for the law to change. Informal pressures need to have impact, or they do have impact, and they can also alert lawmakers as to issues that are affecting the elected representatives. However, the media can be focused on populist issues, and also they are very much focused on the 24-hour news cycle, and therefore that focus may not necessarily be good for the nation, because it focuses on short-term issues, and that's also one of the downsides of our shorter electoral cycle, where longer-term strategic issues are not considered. There are other more formal pressure groups. They're still under the informal banner, but they're a little bit more organised. Here's an example here where you've got a single issue pressure group, the Right to Life. They campaign to keep abortions illegal. There's other pressure groups, and that we could call them professional and industry groups. There's two such examples here. One is the AMA, the Australian Medical Association. So obviously they have they support changes in relation to medical issues that benefit, from their point of view, their members, which are doctors. And you've got the Business Council Australia, and they would be arguing very strongly for them to be advantaged in society. The thing about these groups to notice that they're heavily funded, and they do at times come across very persuasively, and what needs to be said about these is that they serve their own interest, which is not necessarily a bad thing, but you need to filter that in terms of making a balanced decision, especially from a lawmaker's point of view. Get Up. They use social media as a big tool for e-petitions, as I explained earlier. This organisation uses crowdfunding as a major way of funding their campaigns, and they've got quite a few here if you have a look at their site. This organisation follows a lot of human rights issues, environmental issues, as you can see there, economic issues. There's a whole lot on asylum seekers and so forth. So there's a whole lot of issues that they support and try and get the attention of lawmakers in order to change the law. There's a whole lot of formal pressure groups, the ones you don't hear too often. They can exert a lot of pressure on the lawmakers, particularly if they come from the parliamentary committee that's made up of politicians both in the upper house and the lower house. It can be government departments that have determined an issue that needs to be solved, and they do their own research. They can instigate a government inquiry into these matters. In extreme cases, royal commissions. Now that is a form of government inquiry, but it carries the full weight of the legal system, and any submissions that are made, you can be held to account for not presenting truthful evidence. The cabinet, which is the set of senior ministers, the government, what comes to their attention is obviously very important, because 80% of all laws that are initiated come from cabinet. Law advisory committees. The Ombudsman is a government-funded organisation designed to hear complaints about administrative decisions made by government departments. A private members bill is where a member of a parliament can put forward a private members bill that's not sponsored by the government. Commonly private members bill are not that effective, but they certainly highlight an issue. It can also come within government ranks if the backbencher is not satisfied with what the Board of Government is doing. And lastly, the Australian Law Reform Commission. They are an official body set up by the Australian Government and the Tasmanian Law Reform Commission from the Tasmanian Government to investigate certain areas of law reform. Their aim is to modernise the law, and that really takes in point of why laws need to change as values change, and the laws need to change as well. Over time, sometimes there's defects in the law, so they can be sought to be eliminated. Simplification of the law and consolidation of any laws is a similar sort of thing. And sometimes laws are obsolete and unnecessary when they become out of date, and every now and then there are laws that are not uniform between the states and the Commonwealth, and they need to be cleared up as well. The Australian Law Reform Commission is very similar to Tasmania. They also want to bring laws in line with current conditions and needs as values change, provide improved access to justice. The important thing about the Australian Law Reform Commission is that 85% of their reports have been implemented. So they're a very influential agent for law reform in Tasmania. The Australian Law Reform Commission is part of the Attorney General's portfolio. However, it is independent of the government. You can see here that they've got lots of issues that they're looking at: native title, invasions of privacy, and so on. And you can see here that the technological impact has led to a number of inquiries going on, which influence lawmaking on the federal scene. Hopefully that's been a useful introduction to changing the law in Australia.